Well, welcome everybody. It's a great honor and pleasure to be the lead-off panel for this exceptional conference. And I think we're going to have a wonderful presentation for you. The topic, Excellence in Mediation, New Challenges and New Tools. Over the last 5 years, since the pandemic and the lockdowns, mediation has changed dramatically in form, expectations, and institutional role. Yet even sophisticated organizations often resolve disputes late, reluctantly, and at great cost. Our panel is going to explore what has changed, why meaningful early resolution remains elusive, and how parties, counsel, and organizations can make more deliberate choices about when, how, and whether mediation is likely to be effective. We have an absolutely spectacular panel to present these topics. I want to start by mentioning Neil Chatterjee from King & Spalding and Ken Roberts from Venable. I've had the honor of working with both of them in mediations, and I can tell you from my own personal experience, they are two of the most highly skilled advocates I've ever seen in action, and two of the most sophisticated consumers of mediation services with whom I've worked in my mediation career. Also, Cynthia Randall. Cindy Randall is well known to the CPR community, Director of Litigation for Microsoft. Cindy and I recently have taught a number of classes together, and I can tell you from my own personal experience as well that she too is an outstanding professional. And a newcomer to the CPR community, Heather Humphrey from Evergy, an energy company in Kansas City. We're very excited to have her and her company joining the CPR family. And from my brief encounters with Heather to date, I can promise and assure you that she deserves her seat on this very distinguished panel.
We'll see.
We're going to cover 5 topics. We're going to talk about some obvious things and some not so obvious things. We're going to start out by talking about online mediation, perhaps the biggest and most obvious change in what's happened in the last 5 years in mediation. We're going to talk about generational transitions in the field of mediation, both among mediators and among advocates. We're going to talk about the constellation of topics within the rubric of civility, exaggeration, honesty, and advocacy. We're going to move on to what is the definition of a win in mediation, and who gets to determine what a win is. And finally, we're going to talk about the impacts of artificial intelligence, because I think the State Bar of California does not allow you to grant CLE credit anymore unless you say something about artificial intelligence during the program. So let's start off with online mediation. And Neil Chatterjee, if you would please get the ball rolling. We'll spend about 15 minutes on this topic, and let's dig in.
Sure. Well, first of all, thank you for having me here today. I know a lot of you weathered very cold climates to come to sunny San Diego, so welcome to the great state of Southern California. I come from the great state of Northern California. So, I think we all remember about 6 years ago, maybe 5.5 years ago, we were subjected to a pandemic, and all of a sudden, Zoom's stock raised through the roof because everyone started doing both court hearings and alternate dispute resolution through online platforms. And since then, my belief is we're slowly migrating back to seeing each other as real humans. But we've now done quite a lot of online mediations, probably all of you have. My personal belief is online mediation should be used sparingly. And the reason for that is because if you're looking for an evaluative mediation where you have somebody that's really sizing up what the merits and weaknesses of a case are, that could be an effective solution because evaluation has some element of neutrality to it. But I believe that in a lot of mediations, reading body language, making the commitment to actually fly somewhere to go and do something, or drive somewhere to go and do something, with the pressure of people being in a room, often demonstrates a commitment and an emotional view that commits people more to resolution than being able to just click leave. And I think in a lot of cases, mediators really need to be able to size people up. And I've done a lot of online arbitrations and online depositions, and I really hate the fact that I can't read body language. All I see is this, and that may or may not tell me how people are reacting to things. It may show surprise, it may not show surprise. But typically the entire body language is going to be much more of an indicator about how things go. Are people, BSing you? Are they not BSing you? Are they feeling anxious, but they're not demonstrating it through their face, but maybe through other language? Is a proposal in a mediation so negative that people are clenching their bodies or gritting their teeth? I also find sometimes it will be more successful in online mediation if I actually have the client in the room with me. And that makes a difference, because I do a lot of tech litigation, so we kind of live and die by whiteboards. And being able to sketch out what proposed ideas will be on a whiteboard, and then keeping track of what's the bid and ask that's going back and forth, can be a really helpful tool, and we can talk about things more, a little more collaboratively than you can on an online platform. So that's my bias. I don't know how other people feel about it, but that's been my perspective. Evaluative, it can be really good when there's a lot of emotion in a case, and it sounds weird as a tech litigator to see a lot of emotion, but there is often, kind of creative business solutions. I just think the live activity commits people a lot more to coming to a resolution.
Let's hear comments from the others on how you all are balancing the ease of scheduling, the reduction of travel costs, perhaps the ability to get real decision makers involved more easily when they don't have to travel, versus that kind of intimacy that Neil was talking about when people get together in person.
So I'm not balancing it at all, because I agree with Neil. I really hate online mediation. I've proposed it exactly once in my career, which was Rochester in January. And even then, everybody else was in the room in Rochester. It was only me being beamed in. I just think in-person mediation is so much more effective, because it's fundamentally a personal exercise of connecting with the mediator and counsel on the other side and trying to hash out a solution together. And I find it really doesn't work online in the same way. But many people want to do it that way now for all the reasons you just said, Jeff. And so I'll agree to it. I won't propose it, but I'll agree to it if those are the terms that are being offered, because even though that's less likely to resolve the dispute, I think any mediation is better than no mediation, and it could get the ball rolling towards a later in-person mediation or multiple iterations that ultimately get the dispute resolved. But it's definitely second choice in my view.
Cindy, before we move on, your statement that any mediation is better than no mediation, has that changed over the last several years, or has this been a consistent belief that you've had?
I always find it useful. Even if you don't resolve the case, you learn a lot more about the other side and their position and what matters to them, what they're hoping to get out of the dispute, or what kind of terms it might take to resolve it. And it prevents me from getting too entrenched in my litigation position and drinking the Kool-Aid, right? I always think it's useful. Most disputes settle, right? So progress towards that is a good thing.
Great.
Cindy said something really important, though, about her Rochester example, because one place where you can use online tools, right, like a Zoom or Teams or whatever platform you use, is if there's a couple people who can't attend or who might not necessarily need to be in the mediation, but during the mediation an issue comes up and you want to talk to them, I do find it's better to have like a visual platform than a phone call, and it's easier to locate people wherever they are to get them on. And so that can be a technical solution that's kind of available for particularized purposes, where you don't want to fly someone out if they're not going to be needed, but if there's a possibility, you can still get them on.
Well, Neil, I do find that with insurance companies and other large institutional defendants, typically defendants, when it's hard to get the top of the food chain person to come out. And we've had very frustrating moments at the end of mediations when the people who were there recognize they need more money. They call up the food chain and the person at the top says, "You need more money. What did I miss?" Well, they've missed 10 hours of mediation. It's a little hard to recap it. But maybe it's because of the novelty of Zoom or other factors, but I find that these top of the food chain, real decision maker people are willing to show up for half an hour at the beginning of the day and then check in intermittently throughout the day so that at 6 o'clock at night or 9 o'clock or whatever, we're not calling them and shocking them with the idea that they might consider spending more money to settle the case.
Yeah, and from my perspective, Jeff, a lot of times that's the lawyer not doing their job, because with all I don't deal with insurance companies a lot because IP claims are normally excluded under most insurance policies, but normally the insurance companies want regular updates as to what the bid and ask is. And if someone's claiming surprise at the very end, that means they haven't been brought up to speed. I thought of one place where online mediation works really, really well. I do a lot of pro bono cases for prisoners. And we don't necessarily use private mediation. We'll use magistrate judges and typically people in the federal court system. But if you're in prison and you want to try and settle a dispute with the prison system, online tools can be very effective, because one thing that happens a lot is prisoners get moved around a lot between jails. And so a lot of times you'll have a mediation or a settlement conference scheduled, and they go to get the prisoner and they've actually been moved to another facility and it gets canceled. When it's an online platform, it doesn't matter where they are. You just have to do some logistics through the prison system. So for those of you who represent people in prison, go online.
And you know, Neil, I find that the question of the real decision maker, while it comes up very commonly with insurance companies, it comes up with other kinds of parties as well, both plaintiff and defendant. And it really, in a sense, vindicates the purpose of the mediation, which is people have learned things and people have adjusted their view of how much they should pay or how much they should take in order to get the case done.
Yep.
Heather, please.
So I have a little bit of a different view on the decision maker, and coming from an in-house perspective, I'm pretty protective of the upper food chain. I am comfortable calling, making phone calls that we need to do, but would never introduce one of my top senior leaders onto a visual platform like that. I just wouldn't do it for a lot of different reasons. So there are some limitations there as well. I think it's funny because I agree with everything that's been said in terms of the value diminishing with, I'd say the kind of traditional mediation to, as an example, early mediation ordered by federal court. It's kind of a tear down because it's just so early, but you're getting in person, right, to kind of see how things are going. And then on the next level down, kind of the zoom in your point to any mediation is better than none. You want to kind of at least get the conversation going and see if there's something that can materialize. But what I also, the other, perspective on this, I think that, I think there's a real, some people will push hard and argue that this kind of mediation saves money. I would contend it doesn't. Sometimes it'll cost you more money to do something like this. And I think that's a little bit of a different angle that not everybody thinks about when it comes to doing, virtual mediation. Of course, you save money on airfare and a room and things like that. But there is a cost as it relates to the time and the emotional energy. And I think you really have to be on guard when you're doing it like this, that you don't inadvertently, or somebody on your team or the other side inadvertently kind of get dug in a place where nobody really has a whole lot at stake yet. And so, one of the nuances of mediation, I think, is not getting entrenched in a negative position, or things are going to slow down. And if you let that happen, it can happen. I think it can happen a little bit easier, for all the reasons that were stated. When you're doing it by video, and then you can walk away from that mediation in a place that nobody really kind of expected there to be entrenchment, and nobody really expected for there to be kind of this impasse that's created because you didn't you didn't go there in person. I don't know if that makes sense, but I think that that's a real potential cost of virtual mediation.
Ken, please, your thoughts.
First, I think it's timing, size of the matter. Is it a business issue? Is it a legal issue? Have you gotten over entitlement? Are you in quantum? And what I found is if you're truly doing early preventative action, so most of my projects are large capital improvement projects that are going on anywhere from 2 to 7 years, long-term, heavy regulatory oversight. And so if you're in early dispute prevention, you're working out an issue. We'll use a mediator over the course of that 6 years, maybe 7 to 10 times. And we're actually, when we have to report to a state house, when we're reporting to DC, when there's reporting to a board, we're using that mediator to, in essence, count the cards as if we're in Vegas. We're not waiting. I've worked with Heather on some major regulatory matters. We're not waiting to the end of the 6-year project to figure out our testimony. We're counting the cards, we're building our testimony as we go, which has gotten us some of the highest return on rates. And so if you're doing preventative mediation, dispute prevention, I think it's fine to have those, you're not sitting talking about dollars. It's not, you're trying to cut the deal. I'm going to be working with those parties for the next 5 or 6 years. It's going to be a series of issues that we're trying to work those issues. So if it's more convenient to get the parties together to do it, that's great. Here's what I don't understand. I have a major mediation with Eric Green. Those of you here last year saw him, and he's in Concord. And you know, there is an issue where if he says he needs the people at the table, then, you know, to use the nautical example, the mediator's your tugboat taking you through those rocky shoals. And one of the parties said to me, well, do you think we all need to be there? And I did my best John McEnroe. What the, you know? And, you know, if the person you're trusting through that process says, I need everybody there, it's really not the time to have independent thought.
Well, you know, Ken, by comparison, mediators don't wear white coats, but if your doctor says, I want you to come back in 4 weeks for a follow-up checkup, you don't start, most people don't debate the doctor about that sort of thing.
We do, our group does probably 40 to 60 mediations a year. Almost 90% of those are before a claim is filed. So the concept of preventative issue is what our group is built on. And so it's not, we might have 3 or 4 mediations before we get to the one that actually solves what the dollars are going to be, how it's going to be exchanged. And the more that you're doing a long-term project with key contractors, key vendors, you know, the other aspect of it is if you burn the boat down to get the maximum result, you know, you're swimming because you're on the same boat with those folks for the next 3 or 4 years. So it really, you know, when I hear people, I see very few people actually doing multi-year projects with the same parties in the same boat, working those issues. And I would never say yes or no. I love your comment. If it helps progress it, that's exactly what you want to do. It's better than being in litigation. It's better than letting an issue fester. But I think it goes, Jeff, be careful who you select as the mediator on a long-term project. Make sure they're able to, you know, if you're walking across Attica jail yard and your only goal is not to get shivved, probably not the best mediation. If you're figuring out how to survive your jail sentence with everybody together, you're going to have an effective project.
Look, can I just add one other thing?
Please.
That's a little bit of a orthogonal way to go. But when you're doing online mediations, you should also think about what is the virtual tool you're using. Most people default to Zoom, correctly or incorrectly. and this isn't just a plug for Cindy, but I actually think
Plug for Cindy coming.
I actually think Teams is better if you have a document intensive or you want to show things like video deposition testimony, because it integrates better with your enterprise. So like if you're using Zoom and you want to get a critical document, you actually have to go through 4 steps to get the document online to show it to the judge. If you're on Teams, you're already integrated into your enterprise and you can pull things up much faster, and you don't lose that time and kind of futzing around to figure out, okay, how do I share my screen in a particular way, and how do I get the document, how do I put it in the chat, and all of those things. So think about what you might need to do at the arbitration or the mediation, and what are the materials you might want to have access to in an online thing, because that can affect the platforms that you choose.
So Cindy, please get us breakout rooms in Teams, and,
Yeah.
and we'll be set. Ken mentioned the fact that some of these mediations and the kinds of projects on which he works can go on for years at a time. And Cindy, in our preliminary talks, you talked about the generational transitions, both in mediators and advocates. We know that many organizations and law firms rely on a small group of trusted mediators, some of whom are in this room, others of whom are very active in CPR, to help resolve their biggest, toughest cases. But a lot of these titans are in their 80s or close to it. Cindy, what does the future hold? What are the trends, both in terms of generational transitions for mediators and advocates alike?
So I have a couple observations on this. First of all, I feel and I understand why clients and firms want to rely on a small group of trusted mediators, because experience and credibility are just so key. And if you have repeated good experience, that creates a bias in favor of repeated business, right? And both counsel and clients develop a relationship with the mediator that can make future mediation smoother and more likely to succeed. And also, those mediators can achieve that with the plaintiff's counsel too. So you come into the mediation already trusting your mediator, knowing your mediator is effective, and knowing your mediator has the trust of the other side too. So I think those are the dynamics that keep the cadre of mediators that are so senior and so experienced, having potentially a disproportionate share of the work. But at the same time, I think the trends in mediation are moving away from what historically has been a more prevalent style of kind of authoritarian mediation, and more towards a facilitative and service-oriented style. And that sort of style, I think, is more empowering for the parties, and it tends to leave them feeling better about the ultimate resolution. And that changing style is partly a result of changing expectations of the parties, but also the fact that the pool of mediators is getting more diverse, and that's a good thing. So some of the long-established mediators, not necessarily anyone in this room, but with reputations for getting results by banging heads, I think may find themselves on the wrong side of that trend. And I've been doing this a long time, and there was a long stretch of time in the middle of my career where I would be perfectly happy to go to someone who had that style, and I won't do that anymore, because I'm really not trying to beat up the other side. My goal is to come to a mutually beneficial resolution, and so I tend to steer clear of that style these days. And I think clients really have a role here in terms of taking more chances on less experienced and more diverse mediators, because counsel tend to be conservative and default to the old guard. So another trend that I see across all kinds of disputes, and I'd be interested to hear if you all are seeing this too, but it's getting harder to resolve disputes in one day of mediation. So even when you all get together in person and connect and build that trust and see each other's perspective, extend empathy to the other side, all those things, you might not get it done in one day. And so a mediator's ability to establish credibility with everyone and trust on both sides, and his or her willingness to stay involved and leverage that credibility and trust over the long haul to continue to work towards a resolution is really valuable. And those relationship building skills and perseverance are traits that I think are more important than ever.
Ken, you had mentioned in some of our previous conversations that you don't understand why people don't insist on quote-unquote evaluative mediation before taking a case to a trial or an arbitration. And Cindy is talking about what might be a generational shift, and it may just be a difference in how the evaluations take place stylistically. What thoughts do you have in response to that?
The one thing I say to in-house counsel, and I have two of these going on right now, I have zero idea why, if you're facing a 2-3 week arbitration, why if you're facing a 2-3 week trial, I do not get why more in-house counsel are not insisting on an evaluative mediation with a reasoned decision, where the parties are bringing in experts, they're bringing in the fact witnesses. I did the Purple Line last summer in LA. It goes under the La Brea tar pits where there's dinosaur bones. I know this is shocking. There was differing site conditions. You know, imagine that, a place where we did it for a week. I probably have done 20 plus evaluative mediations where I'm writing 120 page decision. I've not seen one matter that has gone to arbitration, that has gone to court, where there is a reasoned evaluative. And if you're in-house, it's crazy. You get to see how your witnesses are going to perform. You're going to see how your experts perform. And the key to that is everybody talks a big game. Everybody knows the answer, you know, to the Wheel of Fortune until the lights are on and you're on the stage. Everybody is, I can beat that. But when you have a report card that says, you know, this is the range, this is what I thought of the witnesses, what I found is everybody kind of shrinks as to telling the in-house counsel, I'm going to beat that. Because they know there's exposure if they make that statement. They know there's accountability. So an evaluative media, if you have a serious matter that is going to go to court, going to go to arbitration, I think you're nuts. I think you're smoking some really good dope that you should sell online if you're not forcing the parties to put up, to walk through that. And when I have clients that have a regulatory aspect, and if you know they are in harm's way with this current administration, why the hell would you put your dirty laundry out there when it's going to be used against you? You want this to be settled behind closed doors. You want to control the spend. I think that's critical. I want to add one more thing, and not as a plug to the CPR, but it's true. When you're looking as to this generational trend, we have a real problem in our ADR space, a real problem. And that is you have a lot of people, more in arbitration than mediation, but how many people in this audience have had an arbitration where something gets kicked and you have a 3-person panel and you can't get that damn panel back together for 8 more months? That's happening all over. How many times is it where you have a mediator where you need an extra day, but they can't fit you in for 2 more months? There's a cottage industry where there are people that are trying to make revenue. And I'm not pissing on their leg. Everybody has a right to make a buck. But they're trying to make the money they didn't make in their first career in a second career in ADR. And I can't tell you the number of arbitrations I've been in where some son of a you-know-what is actually writing a damn opinion during the lunch break. If you have 30 banker boxes of documents that you're submitting in an arbitration or a mediation, you have to ask yourself, and you should be asking the mediator, you should be asking the arbitrator, what is your schedule? Are you just showing up to hear my case? How many days before the hearing, before the mediation are you devoting? If I actually have 30 banker boxers, how are you going through the documents? I'm hired because I have a team that helps me. And we're typically the one that has gone through the documents and has set it up for everybody else. CPR has done a really good job of people that are on their list of they take the game seriously and they're giving people the time. But shame on attorneys and shame on in-house counsel if you're not asking how booked is that person? You know, if you needed another day, can they get back to you in 3 months? Imagine if you told your C-suite, let me get back to you, you know, in 3 weeks. You wouldn't be in your job. You got to press to make sure that if I'm using Kitchaven, if I'm using Green, those are people that have taken dispute resolution beyond, I just want to make a buck off of you, and they're trying to do something bigger and better. You have to ask that panel on arbitrations and mediators, how booked up are you? And if they're just trying to make coin, you know, good luck explaining that to your GC. You know, that's not a damn good answer.
Okay. Heather and Neil, please.
You go first.
Okay, so I was just going to follow on something that Ken said about evaluative mediation and the value of that, and getting back to something that Jeff said, which is really, you know, part of that value that Ken was talking about with evaluative mediation is, you know, you know, as a GC, right, you're leveraging all the time your experience and what you're learning about a case and your relationship with the senior leadership team, making decisions about case value and how we're going to you know, approach strategy and what the outcomes will mean for us and our constituents. That evaluative mediation tool, using it as a tool to get the message across to senior leadership, it goes back to something you said, Jeff, is making sure that they can, what can you leverage to make sure they fully appreciate the exposure and the opportunity that you might be able to capitalize on via mediation. That's one really good way, because you're right. You really don't know how the case is going to come in until the case comes in. It's a very private and very good way to walk the dog down the block. And you know, it's very similar to mock jury trials. When we know we're just going to have a jury trial, it's a very similar situation. It's an investment in really understanding, and that's one of the most elusive things I think about trying to resolve disputes, is really getting a feel for what's the value of the case. Monetary value, but also, you know, I'd say stakeholder value. Ken mentioned we are extremely regulated industry. You know, we're a vertically integrated energy company. We have state regulators that decide what our revenue is going to be, and every single thing that we do is looked at in hindsight. So they get the benefit of looking backwards and judging how we did, and then deciding the revenue that we'll be able to recover based on that judgment. So it really does create a real fertile environment to want to nail it all down, and mediation can really be a path to get that done, and to be able to curate it and narrate how you want that to be ultimately reviewed by the people that are deciding your revenue, right?
Neil,
Yeah.
please.
Yeah, no, I'm going to try and remember the 3 observations I want to make. The first one is so as a tech litigator, I deal with a lot of creepy. And by that I mean, like I'll represent an internet advertising company where the TV is watching you, even though you think you're watching the TV. And when you have mediators that maybe don't live in a world of digital data and digital rights issues, it is harder for them to speak to business people that is their daily currency. And so not only with evaluative mediations, but people who are actually living in that world, because I've certainly had a lot of mediators who really, you know, they don't spend a ton of time, you know, online or dealing with digital rights issues, and that can be important. I also have a lot of tech entrepreneurs who are in these areas. A lot of them are very young. I represented Zuckerberg when it was 6 guys on the second floor of a pizza place, and we mediated the Winklevoss case. And you know, one of the reasons they hired me is because I was younger, and if we had done a lot of mediations with someone who was 80 years old, the business people were so young, they just weren't going to listen to them. That's like talking to their grandparents. And I don't mean to be ageist, but the reality is that some of the people who are hearing the message will be. And so that's an argument, at least, to consider sometimes newer people who have been living in this world. To Ken's point, I recently had a mediation, and the mediator did something that I'd never seen before that I really, really liked. The case did not settle. But he said, I am going to give you a mediator's proposal in 2 days. And what he did was he gave us a report of the mediation and how he sized up how witnesses would be assessed, the key witnesses who happened to be present at the mediation. And it was a 6-page document, and it wasn't like a mediator's proposal of I'm going to smoke out kind of where people are, but instead it gave an argument as to why that number made sense in the context of how witnesses looked and their understanding of the facts. That really helped in going to the board and the rest of the C-suite, because it wasn't just kind of me sizing up what the mediator said to me. It was actually a written document that we could consider based upon a real evaluation of how things looked. And I would encourage people, they're going to do mediators proposals or things like that. It's really, I just thought it was really, really helpful to do something like that. The final thing is that I hate to say this being 56 years old, but at some point I will lose my edge as a practitioner. And I've certainly worked with mediators, over 20 years, 30 years, where they are losing their edge, and I hate to say it, but sometimes, there's some that are great that are older, but there are some that want something to do. I will take smaller cases and try someone new who's younger, who's maybe fresh off the bench, or someone who's decided that mediation is a pathway for them. Just in the same way, I might ask Cindy, like, hey, let's have this young lawyer go and argue a discovery motion in court. And that starts building credibility for the next generation. If you don't have a good experience, it's not a huge loss because it's not as big a matter. And we have to be starting to get experience with those people in order to prepare for the next generation.
Okay, and it's interesting within the field of mediation, the different alternatives that are developing to the 1990s style headbanging approach that Cindy and it seems the rest of you are no longer too interested in enduring. That's a topic for another panel, how we go about the process of evaluation. Let's talk next, and let's try to move a little more quickly through this topic. The whole constellation of civility, exaggeration, honesty, advocacy. We're in a society where standards may be changing or may have changed with respect to some of these topics. How have these societal changes, what do you see in mediation? Ken, if you would get us rolling on that, and then I'll turn to Neil and then the
I'll
others.
be quick. I'm teaching a course at Loyola on mediation advocacy. It's their intensive writing. All of you that have gone to law school, you usually had a writing assignment for your law school that was tacked onto an academic class, which if you're at a large law firm means nothing, right? It's not. So we take the kids, and it's 2 weekends, 8 hours each day, and we bring in the team and as if they're at Venable writing under pressure to try to do a mediation. And the significance of that we're trying to teach them is mediation's different than a motion practice, different than arbitration. You're not the gladiator in the room. You're trying to be a problem solver, and you're trying to present the chessboard so that you're the most reasonable on the options on how you solve something. Not that you win, but you solve it. And what we try to teach them, and it's the top-rated course at Loyola right now, primarily because they get their writing assignment out of the way in 2 weekends. But it's also been really huge in that they like the writing, education. I bring in, Jim has come in, Jeff has come in, Jonathan Marks has come in. We bring the top mediators and some of the top writing coaches in the country. But one of the things that we're trying to stress is the rhetoric, the beating of the chest that you see in a lot of arbitration statements and motion practices. It's just bullshit, and it doesn't help you in a mediation when you have a good mediator. And so I think that teaching we've had a number of practitioners that have wanted to actually sit in. It's really gained traction in Chicago. You've got to be a problem solver writing either the public statement or the private statement in a mediation. And it's a very different technique, as everybody here that has either received a mediation statement or have written one, that really is not taught traditionally at a law school. And if you're counting on your litigation practices to understand that difference, you see a lot of good firms fail because they aren't approaching the mediation statement as a problem solver and trying to set the paradigm of high, low, what are the issues.
Yes, and Ken, I can tell you from the mediator's chair, I often read the briefs and ask myself, of all these lawyers, who is the person to whom I can really turn for the straight scoop when things seem mysterious? Why are people acting certain ways, et cetera? And you want to be that person. You want to be the person to whom the mediator can turn and say, what is really going on here?
Credibility.
Yeah, have that credibility. Neil, I know you have some strong views on this.
Yeah, well, the first thing I'll say on the point you raised, Jeff, is in my mediation statements, we will talk about the merits, but I always like to put in the first section, what are the obstacles to resolution so far? What is my perception of the obstacles to resolution so far? And normally, my mediation statement will talk about the merits, but it's really trying to present that thematic point on here's what's going on in the case, but the reason it's not settling is because of X, Y, and Z reasons. I think the reason Jeff was asking me the question is, and I don't want to get too political on this, but ever since Kellyanne Conway said on a morning news show, these are alternate facts,
Yes.
I have seen a degradation, and this is maybe my personal experience. I have seen a degradation of civility and characterization of facts. It used to be that, you know, you'd read mediation statements and people would emphasize certain facts and de-emphasize others in terms of their relative importance. And that's normal, right? That's what we do as lawyers. These things matter for me, these other things don't. Now I see mediation statements and they're just entire night and day. They're totally different things filled with invectives. And and clients are sometimes looking for people that are willing to kind of sell alternate facts, and I use that alternate facts phrase pejoratively now, where they're not really supportable. And the mediator comes in and says, you know, I don't know what to do with this because you guys are on totally different planets as to what actually happened. And they're not supportable. And sometimes people will accept, you know, the facts or the alternate facts and the invectives. And I think that like, I'm really happy the state bar in California now has people take an oath to be civil, because I think we need to get back to that. I used TikTok on my TikTok feed last night. I watched some of the activities that were happening in the congressional hearings, and I'm not going to say either set of people were, you know, were correct or incorrect, but if lawyers and young lawyers are looking at that as the way that we should behave in contentious disputes, I am really fearful of how we will try and resolve mediation disputes to get to the bottom of what is a productive path forward.
Cindy, Heather?
Yeah, I think the worst thing you can do in your limited time in mediation is treat it like another opportunity to argue the case, right? And this is, I think, more of a counsel problem, and it's something that clients can really address by, at the outset, saying the goal for this mediation is to try to get this dispute resolved. And if we get this dispute resolved on terms that we've agreed in advance are acceptable to us, that is a win. That is a win in the same way that it would be if we won in court. It is a favorable way to resolve this dispute, and it has lots of advantages. And so I think that tends to reduce the dissonance in the counsel's mind between wanting to deliver a win and being at the mediation where ultimately, you know, that could be viewed as not a win or a compromise that is not as good as a win. And so treating the mediation not just as an opportunity to solve a problem, which is a completely different way of thinking about what you're doing than what you're doing in litigation, But also, if that works, that's a win.
I think there's a role for mediators, and really certainly, I guess, all of us, right? Lawyers are trained by other lawyers fundamentally. Ken's not wrong. I mean, when you're in law school, right, there's opportunities to learn about civility and all that. But I do think that mediators can be in a precarious spot in a mediation because you're in a position where you're being selected by people who can choose somebody else, and at the same time, if as a participant in mediation, I would look to the mediator to help manage the temperature, help manage the personalities and the civility in that moment. And I think that can be a really hard thing to ask of somebody there. In a courtroom, a judge can bang their gavel, and maybe they do, maybe they don't. But and there's real penalties that can happen. But I really do think it can be a real detriment to making progress. Some of it's performative, right? As I think you said, Neil, clients can be pursuing, and this is not something new, right? I mean, when we were starting in law firms, you get to know different lawyers and their styles, and you kind of gravitate towards people that you like the style of, and maybe and we all kind of have a different, and you learn from them, right? I think it's just the temperature's gone up so much that's really it's an order of magnitude that's different and can really get in the way. But when it's performative, when you have the client sitting there or watching, and that's what they ordered, they looked at the menu and they said asshole, and they ordered that. You're not going to get away from that, right? And I just think it's one of those things that I ask the mediator to help out, and they have limited, but I think it's something to be aware of.
So Heather, let's drill down on that deeper in the next topic that we've promised to our audience, which is who defines and controls what a win is in mediation, the balance of power and responsibility between the outside counsel, the in-house counsel, the business client, the mediator, managing the tensions between legal risks and business objectives. Has that changed and evolved over the last several years?
I think it has. I'm going to answer from I'm going to put the kind of regulatory lens back on for a second, if you'll indulge me, because I do think one of the things that can be tricky in mediations, this is a topic that could be a full day of discussion in terms of who's deciding when. It's just there's so many layers, and there's so much kind of cultural dynamic in businesses and how we approach these things. Everybody, you get a new case in and you kind of start over here and you're kind of working your way here, right, to get to mediate, to get to a resolution if you can. One of the things that I did a lot of work, I was a trial attorney in Kansas City for a number of years before I went in-house. I did a lot of work for the utility as it existed at the time. We've since merged and grown and done a lot of things like that. But one of the things I didn't fully appreciate until I moved in-house and kind of jumped into the deep end on regulated utilities, regulated entities, right? There's another person in the room, and it's an invisible person. It's a little bit like, and I hate to say this because we are not a governmental entity, but it's a little bit like negotiating with a governmental entity. I had a really good lawyer one time who was a former U.S. attorney who said, when you're dealing with a governmental entity, you are dancing with a bear, and the bear decides when it wants to stop dancing. And the idea is, right, the motivations and the ability to kind of perceive the rational path for commercial entities, businesses, sophisticated parties, that's navigable. It may not always be that you can resolve it, but it's navigable. When there's an invisible hand in the room, and whether that's with a governmental entity that may or may not have the same rational perspective as it relates to kind of commerce and dollars and cents, so do regulated entities, right? So when I first came to the company, the win was not settling. That sounds counterintuitive because we have all this oversight and we are subject to, the reverse look prudency review. The reason that there was a real cultural angst around settling was it's the ultimate second guessing, right? If we go to trial and we lose, it's binomial. It's very easy to say, look, we tried our hardest, we fought the good fight and we lost. Now, give us our revenue. Ratepayers will pay the dime and we move on. There's no second guessing a trial loss. It is very counterintuitive in terms of actual cost, actual time, and actual outcome. You all know that, or you wouldn't be here. So there's been a really, a very intentional path of communication that is required, right, to move outside of those kind of cultural barriers to what is a win. If you are in a situation, and you may not know this if your counterparty is in a situation, that a win is always trying a case, I mean, save your breath, right? And I'm not saying we could never settle something. It's just a different route of, documenting what you're doing, justification for settlement, and always understanding that you could, what it means to be second guessed means to not be able to recover any of the cost associated with that settlement. And so, from an entity that's regulated, right, this path of how do you start having those conversations with your regulator? And right now I'm talking about state regulators because they have their hands on the pocketbook. But I think this absolutely applies to federal regulation and for other places where you've got kind of another hand in the scene that's kind of an invisible thing. And that may be influencing what's happening and how the thought of what a win looks like, how that's being developed, and you may not even know that that's going on. The mediator hopefully will, but I have found that a lot of times if people aren't dealing with that as a kind of an invisible force, it can be a really hard thing to describe and have everybody understand.
Ken, I know you spend a lot of time thinking about these GC and board level issues. Could you comment, please? And then we'll go down the table with Cindy and Neil.
I'd start with what is a win, and I think it's very simple.
A little closer to the microphone, please.
What is a win? I think it's simple. Does your decision maker get better information from the mediation to make an informed business decision, including not to settle? So if I'm taking something to Heather, to Cindy, and they get a better perspective of that case, of the facts, of the quantum from that mediation, and they can tell their C-suite, the mediation was more effective because I now have information as to how I'm pivoting, how I'm making a decision. To me, that's a win. I think the second thing I would say is on, here's a real hard issue. The more that CPR and other organizations push for early preventative dispute resolution, prevention, the in-house counsel knows this. You have this wall that you're hitting between the business unit that is controlling that project, that information. It's their budget, it's their decision. And if they fail, if it goes wrong, it winds up in legal's lap. I tried to climb the 6-foot fence and I got 3 feet splat. Now it's a legal issue, right? And so the more you do that early dispute prevention, you're more in the business unit's business and how you work effectively with that business unit to get a resolution from a legal perspective. That could be just a whole nother panel, because every major project that I'm on, I see that tension, especially the better we're pushing early preventative issues. We are in the lap of the business unit and they don't see it as a legal issue. They don't get that if they fail, it's on the GC's plate. And that tension between the two and how you help the business unit see a win, that it's not legal taking over. But at the end of the day, if they fail, if this blossoms into an issue, it's by definition legal, not business. I think that is a very tough tightrope that I don't see enough effort devoted to.
Cindy, you're the one in whose lap it falls. Legal. Comment, please.
So as I said before, I see most mediations as worth doing, even if they don't resolve the case for all those reasons, right? You learn more, you get the parties closer to understanding each other, you progress towards solving the problem. And, for your stakeholders who are going to be, paying the settlement ultimately or rolling the dice at trial, it's important to see those two options as they develop over time. So I always think of a case as having simultaneously a litigation track and a settlement track, and they're both going at the same time. And you don't know whether ultimately you're gonna end up at this station or that station, but you can see how that's gonna look and learn more about each of those options as you go. And so most mediations are a win, I think. I had one notably that was a loss. And this always stands out in my mind is what you don't want to have at mediation, which is, and this was not when I was at Microsoft, but I brought my CFO to this mediation, and I had pitched this as a very significant case with a lot of exposure, and the plaintiff's lawyers did an absolutely dreadful presentation, and the CFO turns to me and says, "Why would we pay anything for this case?" And that was bad. We made a
That's
low
why I never
offer.
have them
The
come.
other side left. So that was not a win, but most mediations, especially if you go into it, approaching it as a problem-solving exercise.
Well, even there, Cindy, you found out some things about the skill of the other lawyers on the other side, and that's part of the decision-making process as well, isn't it?
True, we won summary judgment, as it turned out.
There you go. And Neil, you deal with tech entrepreneurs, people who are in that C-suite, the founders. How does it look from your chair?
Yeah, so I'm going to say something controversial on a mediation panel. There are some cases that need to get tried. There are definitely some cases that need to get tried. But it's kind of like marketing dollars. You spend $10 and 2 of them are actually valuable, but you don't know which 2 of the 10 it is. It's the same thing in cases that need to be tried. It's not always, you can't always tell which ones are the ones that need to get tried. And sometimes you think you're going to settle up to the last minute and then you don't, and you go and try the case. The big issue that I've seen is, for a lot of companies, is reputational risk. Much more so than dollars and cents. I had a major case for a very big Bay Area company that's very prideful of best places to work, has a storied history in the Valley. We actually did a jury study, and on the jury study, people thought very, very positively about this company. And sometimes there's a reluctance on big companies to feel that way about, but people felt very positive about the history. And in our mock trial, we cast them as being really bad, irresponsible actors. And a number of the senior executives were there, not in the legal team, and they saw how the evidence and what the documents did that would show that. The case didn't have a lot of merit, but the company was saying, we cannot have reporters in the courtroom talking about these documents about us being something other than something we're really proud of. And if it really can be told that we're an unethical company, even if we're legally meritorious, we got to do something about that. And that is something that exists independently of what you can do in a trial, right? And sometimes that is a compelling reason to settle it with reputational risk. And so there's always going to be people in large companies that feel like a settlement isn't a good idea. There are going to be some people that are going to be fire breathers. They want to fight things on principle. But the win is giving finality to a business when there's risks in particular outside of the context of the micro level litigation that I might be dealing with.
Okay, anything else on this topic? I'm going to comment briefly on artificial intelligence, open it up to the panel, and then hopefully we'll have a few minutes for questions. And from my chair as the mediator, I see a big impact of AI on mediation, and that is the question of how important is subject matter expertise in a mediator. It's a virtue in a mediator that many times has been touted above all the rest. I've had a couple of occasions in the last year when I've been asked to mediate cases in areas where I really was not that familiar with the particular provisions of the statute. So I went on to artificial intelligence and I asked it some questions. I took about an hour and a half with each case, and I asked, what are the most, I'm mediating a case involving section thus and so of the statute. Obviously, no confidential information went into the artificial intelligence, just generalities about the types of claims that were being raised and what some of the most significant defenses seemed to be. And I asked, what are the likely sticking points in the mediation? What are likely to be the most significant issues in the mediation? What is likely to hit a mediator by surprise if the mediator is not particularly familiar with the statute? I asked the AI, what are the terms of jargon with which I must be familiar in order to gain the trust and confidence of the parties? And I also asked, what are the things I must avoid saying at all costs so that I don't come across like a dope? And I got pretty good answers. In both of these situations, the mediations went very well, even though before I sat down with the AI, I really did not know much at all about the subject matter of the dispute. So mediation skill may grow in importance as it becomes easier and easier for mediators to acquire the subject matter expertise, which previously was harder to ferret out, and particularly hard to ferret out where the rubber is likely to meet the road. So that's one observation that I have about the impact in the future of artificial intelligence on mediation. Next, I think the second point is that I think it's going to present tremendous opportunities for collaboration and mediation. I had a case a couple of years ago where there was a hot and heavy controversy about the mechanics of exchanging the funds for the release. Some things had taken place in the mediation that led to tremendous distrust between the parties, and they could not agree on the mechanics for the closing of the deal. In fact, they had to go to court in order to have the court's help. And that case has weighed on me quite a bit. Why couldn't we solve that problem? And now I think if that problem came up, I would ask the parties if we could use AI as a collaborative tool. And I think what I would do is, if we're on one of the online platforms, put it up as a shared document. If we're in a physical office, have it projected up on a screen, and then work collaboratively, everybody sitting around the table, on what will the prompts say. And we'd start, I think, with a general description. We are mediating a case arising under section thus and so of a particular statute. Here is the issue on which we have reached an impasse. We have already considered the following solutions to this impasse. List them out. These solutions are not acceptable because, and again, working collaboratively around the table as to exactly what this prompt is going to be. And then I read a wonderful book last year called The AI-Driven Leader. And there was a technique described in this book that I thought was just fantastic that I want to share with you. And that is to prompt AI in this way. Ask us questions one at a time until you are ready to propose 5 possible solutions. And the AI will go through as many questions as it thinks it needs to ask to gather the information that's necessary. And I always ask the AI to let me know when it's ready to propose solutions before it actually does so. Because then I ask one more question. I say, okay, you say you've asked all the questions that you need. Now, if you could ask one more question to get just a little bit of additional information, what would that question be? So asking the AI to ask questions of us to gather the information that it needs, I have found to be a game-changing technique in how I use AI. And I think that when we hit glitches, when collaboration seems to be falling apart in a mediation, perhaps we can use AI. We used to call it the one document approach when Pepperdine taught it in mediating the litigated case years ago. Try to get the lawyers sitting next to each other, working collaboratively on one document. I think we can update that with AI. So those are just a few observations from the mediator's chair as to how AI might actually be incorporated in our practice. Before we turn it over to the audience, we have about 10 minutes left. I want to ask each of you, given all the changes you're talking about, head banging doesn't work anymore, practical business solutions are more important. How would you define what is the mediator's most important skill, and how has that changed over the last several years? What is a mediator's real skill?
So it's several, really. Obviously, you still need someone who has the gravitas and the experience and the intellectual ability to get to the bottom of a dispute, to be able to articulate the key points, to help each side understand from an intellectual standpoint, what are the strengths and weaknesses of the case and so forth. But also, there's just such a set of emotional skills in terms of establishing trust and credibility, in terms of being empathetic, understanding what's really driving each of the parties and what they need to get out of the resolution, whether that's money or any number of other factors, and then being able to bring each side along towards the center of that, and what ultimately will be not just an acceptable resolution for everyone, but one that they can feel is a win.
Neil?
I'll say it. The key thing I don't think has really changed: listening. Listening beyond the words that people are saying, but what's really going on under the surface. And that's why I'm a fan of the in-person mediations, because listening also involves reading body language and people, because the mediators, you have to figure out, do they want something more evaluative? Do they want something, is there a lot of emotion in this? Is there not? Is there, is there a business context to this that's outside of the legal dispute? And you only get that through really careful listening. I do think the use of AI can be helpful as lawyer adjacent, not lawyer replacement. So for example, if you're going to have a CEO of a company, you could ask the AI, tell me about this person. Tell me the things they've talked about that they're concerned about. What did they say on CNBC or Squawk Box or whatever these things are? And you can learn a lot about the people that you're going to meet with at times, if they do spend time online, that can be really helpful for the mediator coming in.
It's a lot more efficient than a Google search.
Yeah.
Yeah. Ken, and then Heather is the newcomer to the CPR family. We'll let you have the last word.
I think it's judgment, credibility, and problem-solving skills. I teach at Northwestern, Loyola, and American University. If a student after the finals that I gave an A to gives me a positive review, do you really think I give a, come on, if they got the A, right? I think that people get wrong in mediation is this is not you fighting with your siblings to get the affection of your mother, who she likes the most. A great mediator is someone, when they deliver bad news, that you can take it to the bank, that they have the judgment, they have the credibility, that you can pivot hard, that you can swallow, that you can, it's not when you win in a mediation that the mediator counts. It's when you have to take bad news back to Cindy or Heather, and having that person that you trust, their judgment, their credibility, that they've bitten into the coin, that your expert isn't delivering what they said they were going to do, that the contract doesn't read as clear as you thought, that the facts aren't leading to that conclusion. So for me, I think the most important skill set is having somebody that, because they are a good listener, but also because they are really super smart and they help you understand that contract interpretation, the experts, that case, if you take it to the next level, it's not likely to produce what your side thinks it is. So for me, a great mediator is somebody that is giving you bad news and you can take it to the bank and you know it's been thoroughly vetted and you can help your side make an informed business decision based on that information. Who cares if they like you, and they're a cheerleader, if that doesn't help settle the case? You can find that a dime a dozen. Give me the one when I have to deliver bad news, and I believe what they say is actually what's going to happen at the next level. That's somebody that I want to use over and over again, whether I quote win the case or we're delivering bad news. It's going to be a more effective ability to solve that issue.
Heather, Heather, please.
Fundamentally, it's that investment that you're talking about. It's the investment of the mediator into the mediation process and informing, like reflecting back to the parties and informing the parties in a way that they understand, right? An informed way that you can take back to your constituents. Anybody can. It's I like what you said, Neil, about AI being adjacent to and not a replacement of. I can query AI to tell me what we should settle a case for, and so can the other side. And I hope to God one day that's not how we resolve disputes, because that's really just like pulling a lever on going to Vegas and a number comes up and that's just what you're going to pay. Because AI can survey the what's happened and I know the case law and all that. That piece of it is helpful. I love the way that you talk about, Jeff, using that as a tool for the skills that you bring to that mediation. And those skills really are that investment that we talked about, getting to know the case so that you can articulate back what the positives and the negatives are, and we can all kind of rely on that.
The kind of mediation that you are hypothetically criticizing when you put it into AI and it comes out, that I think is more like an arbitration result, but without any due process
That's right.
whatsoever.
That's
And
right.
we all know, I like to compare things to card games often. We all know that in poker, for example, you're playing the people every bit as much or more than you're playing the cards.
That's right.
And cases come out differently depending on who the people are and the moment in time at which you find them. We are 72 minutes into our 75-minute allotment. If anybody has a burning question that they would like to ask out loud, it is welcome. Please make it concise. Yes, please.
John Penny, Cincinnati. This is for Ken, because you talked about the evaluation mediation. Could you elaborate a little bit? Is the idea essentially a summary presentation by both sides to the mediator, where the mediator writes up a report, or is it more of an evaluated process in a typical mediation?
Yeah, it's a great question. I'm not talking about a facilitative versus an evaluative mediator in style. I'm talking about the parties have gotten to a point where one or both want to go to that arbitration, want to go to the hearing, and typically what I've been involved with is it's 3 days, it's a week. I've actually done some that are 2 weeks, and there was $380 million in controversy. But they're bringing their witnesses, they're putting them on. It's not like an arbitration, it's not as formal, but you're getting, each side is seeing what the other scheduler is doing, their quantum person. If it's a technical issue, they have some of the fact witnesses that are explaining it. And typically the GCs are coming to observe how their team is performing. And so it's a mini process where you're not trying to find, I think this is the key point, you're not trying to find common ground. This is not a mediation where you're trying to find, hey, can't we work things out? they've already picked up the knives and guns. It's a question of whether they're going to shoot or throw them. And it truly is that evaluation, typically I found it's a high-low, it's not an exact number. And between that high-low, you're giving a reasoned decision that both sides can kick or pick apart. What's
Excuse me.
interesting is almost every one of the evaluative mediations that I've written, been involved, they typically will hire a really good mediator than to do a mediation based on my reasoned award between the high-low, so the parties can work it out.
So,
I think
Ken,
that's really interesting.
Let me take the mediator's prerogative, the moderator's prerogative for the last word. I find that when the mediation is really done artfully and skillfully, and there are many mediators in this room who do them artfully and skillfully, the result, the place where this case has kind of got to come out if it's going to settle, becomes obvious from the mediation process, from the exchange of information and the examination of the ideas. The opinions that the mediator issues are really at their heart confirmations and validations of what the lawyers have all and their clients have already come to believe from observing and participating in this process unfold. And I think that idea of the mediators making it obvious, of designing a process that makes it obvious to the participants, and then validating it, that really takes mediation to a higher art form. This has just been great fun. Thank you all for being here. We've had 4 spectacular panelists: Ken Roberts, Heather Humphrey, Cindy Randall, Neil Chatterjee. Please acknowledge them with your applause.
Great job.
Thank you. Thank you.
Excellent moderation.